Ladies and gentlemen, I am Diane and I will be your host for the session today. Good evening and welcome to the WebEx session, M&A Case Study, L&T's Hostile Takeover of Mindtree. The session will be presented by my colleagues Nishchal Joshipura, Simone Reis, Amudavalli Kannan and Ishita Kashyap. Please note that this session will be in listen-only mode and will last for about 60 minutes, of which first 30 to 40 minutes will be spent on panel discussion. The remaining time will be available for question and answers. Requesting all the participants to be on mute mode for the session. You can post your questions in the chat window while the panel discussion is on. The moderator will queue up the questions for the speakers accordingly. Should you need any assistance during the conference call, you can use the chat option. Do note that this conference is being recorded. I now welcome our session presenters. Nishchal Joshipura specializes in advising on strategic, legal, and tax aspects of controlled transactions, both in listed and unlisted space. Simone Reis, leader, co-head M&A and private equity. Amudavalli Kannan, senior member, M&A and private equity. We are also joined by Ishita Kashyap, who previously worked as a senior member in our corporate team, New York. Over to you, Nishchal, our moderator this evening.
Thanks a lot, Diane, and welcome to all the participants joining this webinar. The topic today is hostile acquisitions in India, with a special focus on L&T's hostile acquisition of Indian IT company Mindtree. The reason why we thought this topic would be relevant during these times is because worldwide, due to COVID-19, the stock prices of many listed companies has plunged. And on account of that, these listed companies have become an attractive target for hostile acquirers. In fact, there are a number of listed companies, both outside India and in India, who are working with their lawyers to devise a poison pill to ensure that there are no hostile takeover attempts that are made for acquisition of the companies. Classic example is Groupon Inc., which is one of the largest online deals company. The stock price of Groupon Inc. plummeted by 67% in last 3 months due to COVID-19. Just day before yesterday, the board of Groupon Inc. adopted a poison pill in the form of a shareholder rights plan, wherein if any hostile acquirer acquires more than 10% of Groupon Inc. shares, the other existing shareholders of the company will get a right to subscribe to one share for every one share that they hold at 50% of the market price of Groupon Inc. at that time. Which means if the shareholder rights plan get triggered, the valuation at which the hostile acquirer acquires stake in Groupon Inc. will become expensive, given that the overall valuation of the company will reduce due to the ability of other shareholders to subscribe at 50% of the market price. In India also, there are many listed companies and their promoters who are in talks with the law firms to see how they can build some of these poison pills in their articles of association and strategizing to ensure that they don't become prey of hostile acquirers in future. As far as India is concerned, although we haven't seen too many hostile acquisitions, there have been few cases where hostile acquisitions were attempted, and at the same time, there have been situations where hostile acquisitions have been successful. However, we don't have more than a handful of cases in India on hostile acquisitions, and the primary reason for that has been that the shareholding of Indian listed company is concentrated in the hands of few Indian promoters, and the financial institutions who form part of public category, they are typically close to the promoters and they usually don't want to side with the hostile acquirer. As compared to the global scenario where the shareholding is fragmented and it's easy to make hostile acquisitions with a better sophisticated set of institutional investors who believe that hostile acquisition is good for the company in long run in a situation where the promoters are not performing. Now, just to quickly run you through some of the successful and unsuccessful hostile acquisitions in India before we move on to the specifics of L&T Mindtree case study. So let me first take the 3 successful hostile acquisitions in India. The first one, L&T's acquisition of Mindtree, which, as I mentioned, we'll discuss in detail in next 5 minutes. The other 2 successful hostile acquisitions in India have been India Cements' acquisition of Rasi Cements. And what had happened was India Cements was holding 9.75% in Rasi Cements, and it managed to strike a deal with one group of promoters of Rasi Cements and bought about 8.28% from that group of promoter. And at that time, the open offer trigger limit was 15% under the takeover code. So an open offer had got triggered for acquisition of additional 20% of the shares, which was the threshold at that time. And the other group of promoters, which did not want the hostile acquisition to happen, they tried a lot to litigate against India Cements and also try and get a counter offer for thwarting India Cements' bid. But somehow they didn't manage to do that, and ultimately they had to succumb to the pressure of India Cements. And finally, other group of promoter also sold their 32% stake to India Cements, and that's how, along with 20% open offer, India Cements managed to get control of Rasi Cements. The second successful hostile acquisition in India was Imami's acquisition of Zandu Pharmaceuticals. And again, here there were 2 sets of promoters, Vaidya family and Parikh family. What Imami did was it struck a deal with Vaidya family to acquire almost 23% of the shareholding of Vaidya family in and along with certain open market purchases, they reached about 27.51% in Zandu Pharma. And based on that, an open offer was launched. What happened was a lot of litigation which Parikh family, which wanted to thwart the hostile bid. But unfortunately for Parikh family, what happened was there was the company law board asked them to settle with Imami. They tried their best to question the hostile acquisition based on violation of insider trading, violation of takeover code, violation of corporate law, breach of right of first refusal under shareholders agreement with Vaidya family. So all these allegations were made. What Imami did was it actually doubled the price it had paid as open offer price to the Parikh family. And since the price was very attractive for Parikh family, they decided to sell their stake to Imami. And that's how Imami managed to do a successful hostile acquisition of Zandu Pharmaceuticals. Now, these are the 3 successful hostile acquisitions: India Cements Rasi, Imami Zandu, and L&T Mindtree. There were 3 other hostile acquisitions which were attempted, but somewhere did not consummate the way the hostile acquirers would have wanted. The first one being, and this was the first ever hostile acquisition attempt in India. This was in 1983 by Swaraj Paul, who tried to acquire and take control of Escorts Limited and DCM, both listed companies. So what had happened was in 1983, the government of India opened up the portfolio investment scheme for non-resident Indians. And Swaraj Paul, being an NRI, he decided to start doing open market purchases in DCM and Escorts. And he actually garnered about 7.5% shares in DCM and 13% shares in Escorts. What followed that was, because he managed to get these many shares, the founders of these 2 companies actually their shareholding fell much below what Swaraj Paul was holding, and Swaraj Paul actually became the largest shareholder in the company. Because this happened, there was a lot of hue and cry amongst other industrialists in India who thought that global NRIs can just gobble up Indian companies due to this NRI portfolio investment scheme. And based on that, what happened was there were a lot of representation that were made to the government. The government intervened. And finally, Swaraj Paul, together with the founders of Escorts, DCM, and the government, they struck a deal. And Swaraj Paul sold his shares to the founders of Escorts and DCM in 1986. That was about 3 years after he first acquired the shares. So although he managed to get majority shareholding in terms of being the largest shareholder, but he could not sustain it for long given the government intervention. The second interesting hostile takeover attempt that was thwarted was by L&T. So L&T has to its credit hostile acquisition of Mindtree, and it also has to its credit thwarting a hostile bid from Reliance and Birla. So this was a case where in late 80s, L&T, Reliance wanted to take control of L&T and it acquired certain stake from open market. Somehow the government intervened and did not allow Reliance to further consolidate its position in L&T. But what happened was, after a couple of years, Reliance, because government did not allow it to consolidate it further, Reliance sold its stake to Birla. At that time, Birla was interested in taking control of L&T. So Birla launched an open offer. But what happened was SEBI came out with certain questions on the open offer and the way Birla through Grasim Industries did the acquisition of shares from Reliance. And then there were a lot of discussions and takeover battle which happened. There were a lot of legal issues which the parties had to go through. And finally, after the long drawn battle, what happened was L&T Management Trust acquired these shares from Birla, and a deal was struck wherein the cement business of L&T was given to Birla. So this was one hostile takeover attempt that was thwarted by L&T. And I think the last one which is relevant is Abhishek Dalmia versus Jesco Corporation. So Abhishek Dalmia was holding about 10.5% in Jesco Corporation, and he launched an open offer to acquire another 45%. What Jesco Corporation's promoters did, they managed to get a white knight in the form of Mahindra Realty. And after a lot of discussions and negotiations, Abhishek Dalmia decided to transfer his 10.5% stake to Mahindra and the promoters, and but obviously at a very price. And based on that, he decided to not proceed further with the hostile takeover attempt. So there have been the 6 or 7 cases in the history of Indian takeover battle which have been there, but obviously these are unprecedented times. The way the stock prices have fallen in India and worldwide, there are a lot of targets which have become very attractive for global acquirers who are sitting on huge pools of money. And this is the best time for hostile acquirers to acquire, and best time, I would say, even for Indian listed companies to adopt a poison pill and structure something so that they don't become a takeover target. So with this, let me move to the L&T Mindtree case study. And my first question is to Simone on how did L&T structure this entire hostile acquisition? And if you can just run us through the nitty-gritties and the issues that were faced with respect to this hostile acquisition.
Sure, Nishchal. So I think, yeah, am I audible? I think yes. Okay. So I think the first sort of, threshold that anyone looks at when you're looking to acquire a company is what is the maximum that I can acquire in this company, and how do I make my strategy really work? And in Indian corporate law, that magic number is really 75% of the shareholders of the company. And the reason why that is because 75% of voting rights in a company really represents the maximum voting power that you need to make things happen in an Indian company. As we know, decisions in a company are taken by the board, and some decisions require the approval of the shareholders. Now, the beauty about the shareholders as well is that to have someone remain as a director on the board is really dependent on how the shareholders sort of react or approve, because more than 50% of the shareholders can also remove a director, and their consent is required to appoint a director. So given that shareholder decisions can be made and require either an ordinary resolution, which is more than 50%, or a special resolution, which is 75%. 75 becomes the magic number, wherein if you have 75% of the votes in a company, you have the ability to control things and move things your way. So therefore, if you look at the acquisition setting of L&T, L&T obviously would really do well with acquiring 75% of Mindtree. Now, 75% is again another magic number, because under Indian securities law, for a company to remain listed, you have to have at least 25% of the shares of the Indian listed company held by the public. And like we discussed, the minute you have the ability to control with 75%, you really become a promoter in the company. And every other shareholder who is not a promoter, who is not really controlling the company, becomes a public shareholder. And therefore, at least 25% needs to be held by the public. And therefore, 75, even under securities law, continues to be that magic number. Now, if you look at the shareholding pattern of Mindtree, and remember this was a hostile acquisition. By hostile, what does it really mean? It means that the promoters weren't really supportive of this acquisition. So it really had to be structured, and in some ways sort of structured blind. So price became very important. Strategy in terms of how to acquire became very important. And the third element is at least one willing shareholder that had a large block became very important. And really, it was a perfect storm that resulted in L&T being able to acquire this company in the way that it did. So you had today, the existing promoters who were not supportive of this deal, holding little shy over 13% of the company. So if you look at the promoters of the company, they held 13.2 in the company. 75 minus 13.2 gave L&T a maximum of about little less than 62% that they could hold they could acquire in this company. And the reason that is, as we discussed before, the total promoter shareholding cannot be more than 75%. And given that this was a hostile acquisition, L&T had no reason to believe the existing promoters would cease to be promoters or would sell their shares to L&T, and therefore that block of 13% could continue to be promoter shareholding. So with that little less than 62% that they could acquire, they had to have the best strategy. They had a willing sort of seller, or a seller that really wanted to sell his shares, which was Siddhartha. Now, and we can discuss the reasons as to why Siddhartha really wanted to sell his shares, and we can discuss that later. But Siddhartha was, of course, a willing seller. He and his group, Coffee Day, held, a little less than 20% in the company. So that was a large block that they could have a direct SPA entered into it. Once you decide to acquire control, under our securities law, one must make an open offer. Now, an open offer is triggered on two accounts. One is if you acquire 25% or more in a company, or you acquire control. Now, when you say acquire control, it really has to be by virtue of shareholding or by virtue of rights in the company. Really speaking, no one was willing to, no one had rights to give L&T. And since this was sort of a hostile acquisition, the promoters really weren't giving away any rights either. So therefore, acquisition of control was really happening through shareholding in this entire scenario. So you had 20% that was really that was a ready block. You had a maximum of 26% that could be triggered as an open offer. Now, even though the open offer requirements is 26%, that's the minimum. You can have, you can always have an open offer for a larger amount. So what L&T did was they upped that offer to 31%. The open offer limit was 31%. And what they also did alongside, because you're never sure really of how shareholders would tender in an open offer, they also placed purchase orders to acquire from the market 15%, up to 15% with their brokers. So what happened was the open offer trigger really got triggered because of the little less than 20% or 20% that was going to be bought from Siddhartha, and the purchase orders of up to 15% that they placed on the market. Now, the up to 15% was really because L&T obviously did not know how much would be tendered in the open offer, and therefore the way the orders were really worked was it was a feel and touch test to see, it was not placed all at once. The purchase orders were to try and see or mop up as much as could have been bought in the open market without necessarily waiting for the open offer to be completed. Now, if you look at 15% plus 31% plus 20%, obviously that went far above 75, and therefore it was the 15% purchase orders was required to be sort of strategized and bought depending on what the open offer would really look like, what the tendering in the open offer would really look like. So therefore, as an outcome of the entire deal, what was bought was 20% from Siddhartha, approximately 8%, approximately 9% through the purchase orders, and the open offer, which was fully subscribed, 31% through the open offer. And therefore, as a result of the total transaction, L&T acquired about 61% of the listed company. Now, in this situation, you would have, how was the entire sort of deal transacted? Because typically, you would have to wait for the open offer to be consumed before you actually, purchase or consummate the primary transaction. But under the takeover code, there is one exception. If you deposit 100% of the maximum consideration payable under the open offer, that means assuming full participation or full tendering, which is in this case was 31%, and 21 working days have elapsed from the detailed public statement that is made, you can, once you deposit this 100% of the consideration, you can actually acquire the primary transaction, subject to, of course, any other regulatory approval that you might have needed for this transaction having come through. In this case, this is how this deal was transacted. Regulatory approvals came through. 21 working days from the detailed public statement had passed, and 100% of the maximum offer consideration had been put in escrow, and the purchase orders were transacted, and Siddhartha's shares were transacted. Thereafter, the open offer tendering period sort of started. The open offer was oversubscribed, and they purchased 31% through the open offer. And after that, there was still a little bit more bought through the purchase orders, which is about 0.58, and that's how the deal got consummated. And you had about 61% being held by L&T.
Thanks, Simone. There is one question which we have received from Nishita on what if the purchase order wasn't executed to reach the first trigger of 25%. And I think a related question is if the purchase order was not placed and it was just a secondary acquisition from Siddhartha, in that situation, would the open offer have got triggered?
Well, technically you can argue no, but really the question really is, can you still make a voluntary open offer without acquiring 25%? And the FAQs by SEBI suggest yes. Even if you acquire less than 25% in a listed company, nothing stops an acquirer from making a voluntary open offer and trying to buy from the market more, through that route. So therefore, could you have made an open offer and reached the same conclusion? The answer perhaps was yes. But again, this is not a very clear position of law. This is really this is not a very sort of crystal clear position under law. It's through SEBI FAQs, because although there is a section under the Takeover Code which talks about voluntary offers, those really kick in only after somebody has acquired 25%. Therefore, leading one to believe that voluntary offers can only be made post acquisition of 25%. That has been sort of debated by many scholars. SEBI also seems to think otherwise. But I think for multiple reasons, the 20 plus 15% and there was no room to make a mistake here with the L&T sort of hostile acquisition. So therefore, for multiple reasons, the 20 plus 15% was actually transacted at one go, leaving no stone unturned.
Sure, thanks. So just one request to the participants. We already got some 18 to 20 questions. What we will do is we will respond to each one of you post the webinar, since we want to use this time of 1 hour to cover all the aspects of the acquisition and the nitty-gritty surrounding it. So you can keep posting your questions, but we would request if you can wait post the webinar for us to respond to the questions so that we can cover all aspects of the acquisition. My next question goes to Amu. Amu, there were certain conditions precedent that were required to be satisfied for the hostile acquisition to go through. Can you throw light on that?
Yeah. So thanks, Nishchal. The question of conditions precedent, let me just take a step back, right? The question of conditions precedent becomes important in a listed company takeover because the takeover code has limited grounds on which an open offer can be withdrawn. There are actually two grounds that the takeover code mentions. One is when statutory approvals which are required for the acquisition are not received. And second is when the conditions precedent to the acquisition, which are mentioned in the underlying documents, are not fulfilled. And this non-fulfillment is because is outside the control of the acquirer itself. Now, these conditions need to be mentioned in the open offer documents at the time of making the detailed public statement so that the public shareholders are aware of the circumstances in which the open offer may be withdrawn. So getting to the first leg of conditions, as Simone had mentioned earlier, there were certain statutory approvals that were required for the transaction to take place. These were basically threefold. One was an approval from the Competition Commission of India. Second was an antitrust approval from the antitrust authorities of Germany. And third was approval from the antitrust authorities of the US. So tackling the India CCI approval first, this approval is generally required when a proposed combination reaches the prescribed thresholds of assets and turnovers of either the individual or the combined entities, again, either in India or on a global scale. So and all of these approvals for antitrust, all these applications for antitrust approvals are driven by the acquirer. So when L&T made the application to the CCI for an approval, it had identified the relevant market for this approval as IT and ITES, basically information technology and information technology enabled services. Now, the CCI observed that the combination is unlikely to have an appreciable adverse effect on competition in India. And it sort of observed that the combined market share of both L&T and Mindtree in India would likely be below 5%. So on these grounds, CCI had approved the acquisition, and this approval came through in the beginning of April in 2019. Now, at the same time, they also received approval from Germany's antitrust authorities. And in US, there is a waiting period within which if you don't receive the approval from the relevant antitrust laws, then it is deemed to be your transaction is deemed to be approved. So this waiting period also expired in the beginning of April in 2019. So in this manner, L&T sort of obtained all statutory approvals which were required for its acquisition. Now, certain other conditions which had to be fulfilled were, one of them was, as Simone had mentioned, the underlying acquisition of shares from each of the sellers and the acquisition of shares on the open market from the purchase orders had to be consummated. And again, as Simone had mentioned, 100% of the offer consideration had been deposited in an escrow account. So this sort of enabled L&T, or rather entitled L&T to sort of entitle them to make this acquisition and consummate the underlying transactions. Another important condition was surrounding the tax liabilities of VG Siddhartha and the Copy D entities. Now, in January 2019, the sale shares which were supposed to be sold by the sellers to L&T had been attached by the income tax authorities, citing certain pending assessments against the sellers. And this attachment was done under Section 281 of the Income Tax Act, 281B of the Income Tax Act, which basically empowers tax authorities to attach any property of an assessee in case there are pending tax liabilities or penalty obligations of the assessee. Now, once this came out, Copy Day had intimated stock exchanges that the revised returns were filed and there were no tax liabilities pending. However, in order to get comfort from any potential tax liability, and L&T had sought for two things from the sellers. One was they had asked for the seller to obtain a Section 281 certificate from the tax authorities, confirming that there are no tax liabilities with respect to the sale shares. And second was they had asked for the order which had been passed attaching the sale shares for this order to be vacated. Now, because this latter condition, basically vacation of the attachment order, because this latter condition got satisfied, L&T waived the requirement for a Section 281 certificate and instead took comfort from a tax warranty from the sellers. Basically, the tax warranty said that there are no tax liabilities pending, and L&T also took a customary tax indemnity for this. Now, in addition to these conditions, there are of course some conditions which are usual to control deals, such as maintaining the truth and accuracy of the warranties until the time of execution, consummation, etc. All obligations under the underlying documents need to have been fulfilled. There may have been certain third-party sort of approvals required as well, like approvals from the lenders, approvals from customers, etc., depending on their commercial arrangements, in case there was a change in control clause in these documents. So we assume that all of these had sort of either been obtained or waived, and on these basis, the underlying transaction had proceeded. Now, in this L&T Mindtree, there was one unique situation which arose with respect to the existing loan obligations of the sellers. Because of this, a bridge financing exercise had to take place. Ishita, maybe you can provide some details on this?
Yeah, sure. Thanks, Amuda. So as Simone and Amuda discussed a little bit on the debt burden that the CCD group was facing, with that background, the Mindtree shares that were held by the sellers were actually pledged with certain existing shareholders. So the sale shares that formed the subject of the SPA had an existing pledge on them. So to cause these original lenders to facilitate the transfer under the SPA, Tanglin Finance, an associate company of the sellers, issued NCDs and raised another financing from several other lenders. The amount that Tanglin raised was used to repay the original lenders of the sellers, to release the pledge from the original lenders. Now, while this NCD was issued for a period of 1 year, there was a mandatory redemption condition in the NCDs, which required a mandatory redemption on a sale event. Sale event was defined as, the sale of shares by the sellers to a third party. So, when the sellers ultimately sell these shares to L&T, that would amount to a sale event and trigger the mandatory redemption. Uh, to give effect to this transaction, this arrangement that had been agreed, and to sort of as an agreement with the Tanglin lenders, escrow agreement was entered into among the sellers, L&T, an escrow agent, and the debenture trustees. Pursuant to this escrow agreement, what happened was the acquirer, L&T, agreed to deposit the entire SP consideration, and the sellers agreed to deposit the total sale shares in an escrow account. What was supposed to happen and what actually happened on the day of the sale was that the debenture trustee would revoke the pledge that was created on these shares, and a waterfall mechanism was agreed to. So according to this waterfall mechanism, the payments were prioritized to Tanglin lenders before they could make their way to the sellers. This execution of escrow and this entire arrangement was also a part of the CPs in the SPA. So this is really how L&T sort of took care of the existing encumbrances on the sale shares.
Understood. And Ishita, is there any reason why the sellers decided to go with L&T, given the fact that the sellers were also very close to the promoters who were actually not very comfortable with the hostile offer?
Yeah. So VG Siddhartha and the CCD group that was shareholders in the company actually came in pretty early in Mindtree. They were one of the early investors in Mindtree. VG Siddhartha shared a close relationship. He was very friendly with the promoters of Mindtree. It was all over the news that the promoters were not happy specifically with the sale to L&T. And in this sort of situation, L&T still went ahead the seller still went ahead with L&T. The main reason is, the dynamics of this deal were slightly complicated than, a plain vanilla transaction. As I briefly touched, that the CCD group was heavily burdened. Vijay Siddhartha was also, facing some personal debt issues. In January, we may all remember that it was reported heavily that IT authorities had attached Vijay Siddhartha shares, and like Amuda also mentioned before, most of the shares of L&T, most of the shares of the sellers in Mindtree were anyway pledged with the lenders. So any investor coming in would have to be really okay with the title of the shares, the subject shares being sort of questionable to that extent. The investors would, have to agree to a mechanics where the shares would have to be first depledged, or, some sort of a structure where the shares will have to be first depledged, or at least the investors would have to agree to some sort of pledge being in picture while they sign a deal. This is not, likely to have been fine with some of the global PEs who were also reported to be interested in the deal earlier. So to my mind, one of the important reasons that kept away some of the other investors was all of this complicated dynamics. L&T, on the other hand, was able to strike a deal in spite of all of these complications. And some of the CPs that Amuda explained, and the Tanglin refinancing sort of is where L&T found its comfort, and decided to move on with the transaction. There are a couple of other reasons that may have contributed to this sale. One of it is one of the reasons is that the dynamics of this deal were not usual. This deal was prompted by a unilateral decision of Siddhartha to sell his shares. There was a huge liquidity crunch that the group was facing. So in that sense, it was a sort of fire sale. They did not have, the liberty of time to wait for the right buyer in that sense, which the promoters agreed to. L&T also offered the best price. The share price was agreed at 980 per share. The second best offer that was reported was at 975, while the overall benefit would have been 164 million, which is not a huge number when you look at the entire deal. But some of these other factors, contributed to sellers picking L&T. I think just one last thing that also may have contributed to the sellers going with L&T is that, as Simone explained, that the promoters were not really keen on giving away any sort of control in the company. There were reports that PE investors, and as is usual for PE investors, to ask for certain special rights and at the least the board right. It was reported that the promoters were not really willing to give away some of these rights. So the only way to really get into the company was to acquire control through a shareholding control, and I guess L&T had the appetite for that. So these were some of the reasons why other Ps were turned away, and the sellers finally went with L&T, even though the promoters were not really happy with it.
Thanks, Ishita. So Nishchal, I think, when we structure deals, especially for control deals, right? You always have a shareholders agreement between two parties. And maybe in hindsight, if, the promoters of L&T had a shareholders agreement with Siddhartha, or had some sort of restriction on who they could transfer to, saying that, control, etc., could not be transferred, or couldn't sell a single block, or had a right of first refusal or first offer, those were things that perhaps the promoters of L&T could have done, promoters of Mindtree could have done to actually, thwart maybe an open offer and a takeover. They tried to do buybacks, which also failed. They could have done maybe a dividend outflow and made this a little bit more cost ineffective for L&T. They could have done various things, but I think you did talk about takeover defenses and poison pills. What do you think globally are the typical takeover defenses, and how do you think these defenses can actually work in India, especially in a situation like a Mindtree?
Sure. So, in fact, globally, there is a lot more flexibility to structure some of these takeover defenses compared to what we have in India. And I'll quickly go through some of the takeover defenses which are adopted globally. The first one is buyback of shares at a huge premium, so that the entire cash which is sitting in the company can be paid to the existing shareholders, which makes the target unattractive for the hostile acquirer. Unfortunately, in India, under Regulation 26(2) of Takeover Code, during the offer period, the target company is not allowed to buy back its shares without the prior approval of 75% of the shareholders of the company. And this is something which obviously in this case became an issue, because L&T was not only talking to Siddhartha, but was also talking to many other institutional shareholders to garner support for this hostile acquisition. So it would have been difficult to, pull this through successfully for Mindtree. The second important takeover defense is the poison pill in the form of shareholder rights plan, which I just mentioned at the beginning of the webinar on what Groupon Inc. did. What it means is that there is a right which is given to the existing shareholder to subscribe to the shares of the company at a huge discount to the price at which the hostile acquirer is buying shares. so that overall the value of the company reduces for the hostile acquirer. The third important takeover defense is what we call staggered board defense. What it means is there can be staggered board arrangements which could be built into the charter documents of the listed company, where it is mentioned that certain types of directors cannot, a certain percentage of directors can only be removed in 1 year, and the rest of the directors can be tranched out over a period. What this means is that hostile acquirer may not be able to replace all the directors at one go. This is something which is quite frequently used globally. But in India, as we know, under the Indian corporate law, more than 50% shareholder can replace the entire board. And hence the staggered board as a concept, even though for public companies, we have the concept of retirement of directors by rotation and all those things. But uh, as I mentioned, more than 50% shareholder can replace the entire board. So that's something which doesn't work well in India. We also have concepts of shark repellents globally. What this means is there are certain provisions built into the charter documents of the company, which make it unattractive for the acquirer to take certain actions with respect to the target company. In India, we have, certain, if you see the articles of association of some uh, holding companies of large groups, there are some of these repellents which are built in the articles in the form of share transfer cannot happen to certain types of people, especially competitors. Uh, if somebody crosses 10%, then without the consent of the existing promoter, board members cannot be appointed. And some of those restrictions are built in the articles so that it becomes unattractive for the hostile acquirer to acquire shares where they may not have control over the ability to get rights in the company. We also have brand pills in the Indian context where some of the large groups in India, uh, their holding companies, they have the brand, and this brand is licensed to the listed companies. And there are these brand pills which are built into the articles of the companies that if the licensor ceases to remain in control of these listed companies, then automatically the brand arrangement terminates between the licensor and the licensee, and that itself becomes a huge uh, 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 value reducing event for the hostile acquirer. So that's something that we have seen in the Indian context. Golden parachute is one more thing globally that we have seen, where if there is a hostile acquisition and the new acquirer wants to replace the top management of the company, then there is a substantial severance package that is to be paid to the top management of the company. And interestingly, not in the context of hostile acquisition, but the CEO of Walt Disney in 1995 when he joined, Michael Ovitz, he had negotiated a severance package of $140 million. Within 14 months of joining Walt Disney, he left Walt Disney with a $140 million severance package that was questioned by the shareholders. But finally, the court ruled that Michael Ovitz is entitled to get this $140 million because of the golden parachute that he has negotiated with Walt Disney. So this could also become a huge drag in the employment agreement for the key managerial personnel from an Indian context. You can build some of these defenses where the main guy who is running the company, there can be a substantial severance package in case of hostile acquisitions to make it more unattractive for the hostile acquirer. Then we have crown jewel disinvestment, where the most important asset of the listed company can be divested to third party with an obligation to with the third party to buy it back at a certain price. So some of those things can be looked at. There is also a concept of Pac-Man defense. What it means is that the target company itself starts buying acquirer shares and launch a reverse hostile bid, which also globally has happened in certain situations. We haven't seen this too much in Indian context. But broadly, Simon, these are the key global takeover defenses that we have seen. But given this defenses, and I think you briefly touched upon it, was it not possible for the promoters of Mindtree to use any of these defenses to thwart the hostile bid?
So Nishchal, I think, even in the past, I think the most widely used defense has always been the white knight defense in Indian situation, where you need to diffuse a hostile sort of acquisition. And in fact, L&T itself had used Reliance, previously as a white knight when there was a hostile acquisition of L&T being sought at the time. So I think but all of these really require cash, right, and time. And I don't think the Mindtree promoters had either cash or time at that time to facilitate this transaction. Could they have done other things like perhaps planted, a poison pill or a brand pill? Perhaps yes. Did they try other things like trying to do a buyback to make the target less attractive? Yes. But I think the entire relationship between the Mindtree promoters and Siddhartha was really one of, it was a very friendly relationship. Siddhartha had previously also wanted to really sell his shares, and then, because of the promoters' request, did not do so. But I think given the overhang of debt that was really circling Siddhartha, the Coffee Day sort of group, they had really no choice but to sell, and which is why the relationship broke. And despite attempts to try and seek friendly buyers, this could not be done within the time frame that the promoters really wanted. And I think the last bit that really led to this hostile acquisition was the fact that the promoters really did not want to cede control. So even though there were white knight, perhaps white knights that could be found, without the promoters without really them ceding control, the universe was perhaps quite limited, right? And when you have a war chest like L&T, in fact, L&T didn't even require shareholder approval for this transaction, which means that they really had a large war chest. It was all cash, didn't require lenders, further borrowing. So I think all in all, this was a very difficult battle to fight. It was really the perfect
storm. So I think this is a classic wake-up call for a lot of listed Indian companies who have very less promoter shareholding and the stock prices are low, or in situations where there are two groups of promoters who are fighting with each other, where it is possible that one group may side with the hostile acquirer and then the takeover battle starts
Absolutely.
with the second group of promoters. So interesting times.
But, and just to add, SEBI has now also is looking to sort of allow for superior voting rights, which wasn't the case before. So with superior rights, I think maybe there are other sort of creative ways to try and see whether defenses can be built in. So let's see how that really works out.
Amu, my next question to you is obviously given that this was a hostile position and regulation 26.2 of takeover code anyways does not allow the target company to take certain decisions without the consent of shareholders. There was definitely a desperation from L&T's side to induct its directors on the board of Mindtree, even while the offer period was on, to ensure that there is nothing which is done by the board which can thwart the hostile bid. So what was done by L&T to ensure that they managed to induct their directors on the board during the offer period?
Right. So Nishchal, like you mentioned, given the hostile takeover context, there was an urgency for L&T to enter the board and to take over the management as soon as possible. Now, the takeover code, like you mentioned, actually does not permit any acquirer to appoint a director on the board of the target company while the open offer is still pending. However, the takeover code does make an exception for if two conditions are satisfied. So one is where the acquirer has deposited full consideration for the open offer in an escrow account. And second is where the conditions precedent to the acquisition have been satisfied or waived. Now, we know that these two conditions were satisfied because these were also similar, there were similar conditions for the underlying transactions to take place. So because these two conditions were satisfied, they had to wait for a period of 15 working days from the date of releasing the DPS post which they were entitled under the takeover code at least to sort of induct their directors on the board. So after this, it was just an procedure to be followed under the Companies Act. So the directors nominated, or rather the individuals whom L&T wanted to enter in the board had to make a written statement to the board conveying their intention to be appointed as a director and make a deposit of 1 lakh rupees. And by this time, this was somewhere in June 2019 when the offer had been made, and it became a little clear that that the takeover attempt is sort of going through. So the nomination and remuneration committee also of Mindtree, and subsequently even the board of directors had approved the appointment of these individuals. So 3 of these individuals were appointed as non-executive directors, and 2 were appointed as independent directors. And later on, their appointment was also approved by the shareholders in a general meeting in July. So in this way, L&T sort of managed to take control over the board of directors as well. In the meanwhile, in the background, all the existing promoters and their representatives, sort of resigned from all of the executive posts that they were holding in the company, such as the CEO, post of the COO, chairman, vice chairman, etc. So in this way, L&T sort of managed to establish itself in the board.
Other question which is there, as I understand, is how did the existing promoters of Mindtree, are they still considered as promoters, or are they considered as public? And what we understand is, as per SEBI listing, as per the listing regulations, there was an amendment that was made in November 2018, wherein SEBI has allowed the existing promoters of a listed company to reclassify themselves as public shareholders subject to satisfaction of certain conditions. And primarily, there are 3 conditions that need to be satisfied. The first one being the promoter has to be holding less than 10% voting rights. The second one is the promoter should not be having any position either with him or any of its relatives or affiliates as director on the board of target company or key managerial personnel in the target company. And the third one is there should not be any special rights in the target company. If these 3 conditions are satisfied, the exiting promoters can send a request to the company to declassify themselves as promoter and reclassify them into public category. And based on that, the board takes a decision subject to approval of the shareholders on whether these shareholders can be promoters can be reclassified as public shareholders. As far as the facts are concerned, the request was sent by the existing promoters to the board of Mindtree after L&T took over to declassify themselves as promoters. The board of Mindtree approved their reclassification from promoter to public category, and it is awaiting the nod of shareholders of Mindtree, which means that as of today, in addition to L&T, even the existing promoters, individual promoters of Mindtree prior to the acquisition are also appearing as promoters of Mindtree. And once the entire shareholder approval process and the declassification happen, they will move to the public category. So with this, I would like to hand over the mic to Deanne. I think the only concluding remark that I have during this COVID times, especially for promoters of listed companies, is stay safe, since times are not good for listed companies. And just like COVID, there could be many hostile acquirers which could gobble the listed companies. So with this, over to you, Deanne.
Thank you, Nishchal, Simone, Amudavalli, and Ishita for an interesting discussion this evening. Our next session will be held at 2100 hours today on recent developments in the telecom space Wi-Fi, anti-spam, net neutrality, M2M, OTT, and OSP. This will be followed by 4 interesting sessions tomorrow. At 12 noon, we have Founders One-on-One Legal and Tax Series in collaboration with TIE and IAN on employee stock options, structuring the right plan for the right employees. At 1500 hours, we have Litigating in India during the lockdown, how are courts hearing the case, interactive session with Justice A.K. Sikri, retired judge, Supreme Court of India. We have at 1800 hours 3D printing, the next frontier, legal and tax issues. And lastly, tomorrow at 2100 hours, we have how to litigate patent disputes in India. You can register on our website or through LinkedIn. Thank you for joining us this evening. You may now disconnect your lines.
Just one announcement. We have received number of questions from the participants. So we will be responding to each one of you in the next couple of days. And thank you all for joining this webinar.